In this series of videos, we will discuss certain important leading cases on law of contract and so also the very principles involved in those leading cases in brief. So the first leading case that we will discuss is Alcott versus Skinner, a leading case of 1887, where the plaintiff in middle age joined a Protestant sisterhood taking vows of purity and obedience. She gave property of the value of £7,000 sterling to sisterhood in accordance with her vows. Some 9 years later, she left the order to become a Roman Catholic. Only £1,671 sterling of her property remained with the sisterhood, the balance having been spent. Plaintiff claimed the return of £1,671 sterling from the Mother Superior, that was Miss Skinner, and alleged undue influence, held that undue influence existed in this case since the plaintiff was bound not to seek independent advice while in the order and from other. However, the plaintiff's claim was barred by her delay of 5 years after leaving the sisterhood in claiming the money, as she was guilty of delay, which is called laches. The plaintiff was presumed to have affirmed her gift and her claim fell. And the second important leading case in law of contract is Carlyle versus Carbolic Smoke Ball Company, and it was a case of 1893. So here a patent medicine company advertised that it would give £100 to anyone who contracted influenza after using their smoke ball for a certain period. Plaintiff Miss Carlyle brought the smoke ball and used it as directed and contracted influenza. Nevertheless, she claimed the reward of £100, and it was held that plaintiff accepted by complying with the conditions of the offer. There was an offer capable of acceptance by all who used the smoke ball, and it mattered not that the plaintiff did not communicate or acceptance to the offer. And the third important leading case that we will discuss is Hadley versus Banksdale, and it was a case of 1854. The very fact of the case was that a miller sent a broken crankshaft by a carrier to deliver to an engineer for copying and to make a new one. The miller informed the carrier, which accepted the consignment on those terms. The miller did not inform the carrier that the mill would be idle and unable to work. The carrier had no reason to believe that the crankshaft was an essential mechanism of the mill. The carrier delayed delivery of the crankshaft to the engineer, and as a consequence, the mill was idle for longer than it need to have been. So it was held that the carrier was not liable for the loss of profits during the period of the delay. The court, in its judgment, laid down the principles as follows. First principle, it was held by the court such damages as may fairly and reasonably be considered as arising naturally, as example, according to the usual course of the things from the breach of contract, or the second principle, such damages as may reasonably be supposed to have been in the contemplation of both parties at the time when they made the contract, as the probable result of the breach. So now we'll go to the fourth leading case, and that is was Ben versus Fethergill. So the fact of the case was a purchaser of real estate cannot recover damages for the loss of his bargain, but only his deposit and expenses, and that even if the vendor knew that he had no title nor any means of acquiring it, the purchaser may have a further remedy by an action for deceit, but not on the contract. The reason for this exceptional rule is that the purchaser of real estate in England must expect some degree of uncertainty as to whether a good title can be effectively made by the vendor, whereas the vendor of a chattel must know, or at all events is taken to know, that his right to the chattel is. The rule in Ben versus Fethergill was at one time assumed in the High Court of Bombay to be the law of India, but Section 73 is general in its terms and does not exclude the case of damages for breach of a contract to sell immovable property, and in fact the rule was not settled beyond question in England when the Act was passed. And the next important leading case that we'll discuss, it was a case of India, and that was Mori Bibi versus Dharamdas Ghosh. So the very fact of the case was Dharamdas Ghosh executed a mortgage in favor of Brahmadatta to secure repayment of Rs 20,000 at 12% on some houses belonging to him. At the time of mortgage, he was a minor. So the Privy Council held that agreement was void ab initio. The question whether a contract entered into by a minor is void or voidable has given rise to conflicting decisions in the past. The majority of Indian High Courts held following the English law that a minor's contract is at his option. It could be ratified on his attaining majority and not void. This view continued to be held till 1903. As for the decision of the Privy Council in this leading case of Mohri VP versus Dharamdas Ghosh, in this case the Privy Council held that a minor's contract is absolutely void and not merely voidable. He being a person who is not competent to contract. So Indian Contract Act makes it essential that all contracting parties should be competent to contract and expressly provides that a person who by reason of minority is incompetent to contract cannot make a contract within the meaning of the act. Thus, where a minor borrowed Rs 20,000 from B and as security for the same executed a mortgage in favor, B's favor, it was held that the contract was void and that A could not therefore be compelled to repay under section 64 and 65 the amount advanced to him by B. So the decision in Mohri Bibi's case makes it clear that a minor or a person of unsound mind is not competent to contract. Such a person is thus a person who is incapable of entering into a contract. This makes Section 68 applicable to such a person, and Section 68 states that if a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who had furnished such supplies is entitled to be reimbursed from the property of such incapable person. And now we'll go to another important leading case, and that was also relating to India, and that case is Khwaja Muhammad Khan versus Hussaini Begum. So, in this case, she sued her father-in-law A to recover arrears of certain allowances called Kharchai Pandan payable by A to C under an agreement made between A and C's father prior to and in consideration of his marriage with A's son D. Both C and D were minors at the date of the marriage. The agreement created a distinct charge in favor of C on certain immovable property belonging to A for the payment of the allowance with a right to enforce it. It was contended on behalf of A on the authority of the leading case, Tweedle versus Atkinson, that she could not sue upon the contract as he was no party to the agreement. But this contention was overruled and the suit was decreed in the circumstances of the present claim. Their lordship said that in India and among communities circumstanced as the Mohammedans, among whom marriages are contracted for minors by parents and guardians, it might occasion serious injustice if the common law doctrine was applied to agreements or assignments entered into in a connection with such contracts. Tweedle versus Atkinson was distinguished on the ground that it was a case of an action upon assumptions. So, Khwaja Muhammad's case had been applied to cases where a provision is made for the maintenance of female member of a Hindu family on the partition of the joint family property between the male members. The female members, though not named as parties to the contract, possessed an actual beneficial right which placed them in the position of statutory trust under the partition. Similarly, where a provision is made for the marriage expenses of a female member of a Hindu family on a partition of the joint family property between the male members, the female member is entitled to sue the parties to the partition deed to enforce the provision in her favor. And our next important leading case, and that is English leading case, and that is Lampley versus Braithwaite. So, in that leading case, the case embodies the rule that a past consideration to support a promise must be moved by a previous request. The general principle is that consideration is given and accepted in exchange for the promise, as the consideration and promise are simultaneous. The consideration must always be present. A consideration, if past, may be the motive but cannot be the real consideration for a subsequent promise. But if services have been rendered in the past at the request or desire of the promisor, the subsequent promise is regarded as an admission that the past consideration was not gratuitous, and which is evidence of the amount of the reasonable remuneration on the faith of which the services were rendered. And our eighth most important leading case under law of contract is the Oceanic Steam Navigation Company versus Sundar Das Dharamse. So the very case is based on Section 18, Clause 3 of Indian Contract Act regarding misrepresentation. In this case, the defendants in Bombay chartered a ship wholly unknown to them from the plaintiff, which was described in the charter party and was represented to them as being not more than 2,800 tonnage registered. It turned out that the registered tonnage was 3,045 tons. The defendants refused to accept the ship in fulfillment of the charter party, and it was held that they were entitled to avoid the charter party by reason of the erroneous statement as to tonnage. The principle underlying in this case under section 18 subsection 3 is misrepresentation, means mistake as to the substance of a thing which is the subject of the agreement caused by the other party innocently. So, we have discussed 8 important leading cases with the very principles involved in brief, and in our upcoming video will discuss the other important leading cases relating to law.